Hello and welcome. My name is Ali. I'm the owner and founder of Goff Legal. We do estate planning, trust administrations, and probates here in California. This video is called How to Avoid Common Estate Planning Mistakes. This could be like years long topic. Of course, there's lots of things you can mess up, but the good news is a lot of them fall into sort of a few big categories. And my hope is by getting you some of the big ones, you can identify those and realize whether you need to check in with your attorney or go look at your binder and figure out if that's something you need to deal with. Number one, most common mistake I see, especially with people who get their documents from an online preparer or a company that doesn't actually walk them through the signing, is that they don't execute the document properly. Either the witness doesn't have two wills, the will doesn't have two witnesses. Ooh, flub up today. Or the power of attorney, where it has a section on authority, doesn't actually initial any of the authority, so they don't have any authority. Sometimes it's having a relative, the trustee or a beneficiary, witnessing a will or a family member notarizing a document. No, no, no. Those things do not work. They will not work. They will cause problems and will cause lots of money in estate planning attorney and trust administration attorneys' pockets when you're gone. Don't make that mistake. It's sort of a simple mistake, but also it's really, really important. So documents need to be executed properly. We need to make sure that all that's buttoned up. I actually had a really unfortunate situation where a client came in and said, I'm power of attorney, but the bank won't follow it and the title company won't honor it. And I looked at the power of attorney and the notary, unfortunately, notarized the signature of the agent, the person who's supposed to act, and didn't notarize the signature of the principal, the person that was signing it. It was a totally irrelevant and useless document. And it was so stressful for my client. So let's not do that. Number two, common mistake we see, not actually funding your trust. Funding meaning transferring assets into the name of the trust. Here's your house. It is beautiful. It's in your name as an individual or your name as a married couple. In order for it to be in the trust, the title actually has to change on the deed to your name as trustee of your trust or your name as trustees of your trust if there's more than one of you. This counts for bank accounts, brokerage accounts, stocks, bonds, promissory notes, some real estate, business entities, sometimes vehicles if they're worth enough money. The other thing you can do to fund your trust is to make sure that the accounts that aren't in the trust, because there's some over here, IRAs, 401ks, life insurance, those need a beneficiary designation. So two parts, putting stuff in trust, I'm the trust in this scenario, and making sure that your documents, your non-trust assets have a beneficiary listed. This is so important. This is one of the main reasons why we end up in court. Not because people are fighting, but because the banks and the institutions cannot give you control of an account that is not titled in the name of the trust when you're dead, right? We can't have your family go in and gather the asset. We get to go to court. And I say get to, it's not a fun process. It's expensive, it's time consuming, and more money ends up in the attorney pocket than the beneficiary pocket. This isn't a win-win for anyone. A win-win for everyone is that the person who creates the trust either funds the trust themselves or they hire someone like our office or work with their financial advisor to fund their trust. So important. Okay, common estate planning mistake number three. This one I sometimes get a little flack for, but it's co-trustees, it's co-agents. If there's one reason litigators make a lot of money, it's co-people, right? You have a co-power of attorney, co-trustees, co-executors. Now, not all situations are terrible. Sometimes it works out really well, and there are certain circumstances where co-relationships can be a good idea. But I will tell you, most of the disputes that end up in court are often because there are two people who have to make decisions and they don't agree. On top of that, let's say they do agree. Let's say that everyone's getting along swimmingly. Well, now we might need two signatures on everything, two signatures to open a bank and transfer it, two signatures to collect an account, two signatures to transfer the house and sell, two, Do you see how annoying that gets? That's pretty annoying for me, but it's pretty annoying for the trustee who's like, I thought we was going to be able to delegate this to my brother and I would just supervise. It doesn't always work that way. So before you have co-trustees, or if you do have co-trustees and you're like, oh, that could be a problem, let's make sure that it really is the best for your family. And then fourth most common mistake that I see is a lack of succession planning. That means failure to nominate backups. Case in point, I create a trust and I nominate my husband as trustee, and then I nominate my sister as the backup trustee. Cool. Now, if the three of us like to vacation, as we sometimes do, if all three of us are gone, who's going to be trustee if it isn't all of us? Sometimes I'll just see one person's name, and sometimes that person is 90. Maybe we want to think about naming person 2, 3 down the road. You can often use licensed private fiduciaries as backups. You can have trust companies as backups, friends, family members. The more backups you have, the less likely you're going to end up in court because of an administrative issue, like not having a trustee who is willing and able to serve. Now, this goes for not only your trust. This is your power of attorney. This is your healthcare directive. This is your executor, your will. All of that is really important to make sure that you've got backups in place. And the same goes for beneficiaries. I'm going to leave all my money to my child. And we don't want to think about it, but if something happened to your child before you need a backup. Maybe it's your favorite charity. Maybe it is a charity and some friends. Maybe it's a family member. Maybe it's a couple family members. Whatever it is, consider that we might be able to change your plan later. So we need to get some backups in place. So those are my 4 tips on common estate planning mistakes that you can now avoid by looking at your documents and making sure everything's in order. And if you're like, oops, uh-oh, I have a problem, no worries. Call your attorney, get a meeting on calendar, review them, and make sure that these things are not a problem for you. If you don't have an attorney or your attorney retired or passed away, which sometimes happens, feel free to give our office a call. You can find our website at gofflegal.com.